Hello, doctors. I'm Dr. Chris Rapoff of Easy QME Continuing Education, and welcome to this week's Case Law Update. Before we get to today's case, I do have a question for you. Have you ever provided an impairment for an applicant who gained 100 pounds after leaving his job, and you don't apportion for obesity as a, quote, other factor? Well, today you'll learn about a National Hockey League goalie who retired and did just that. And I think you'll be surprised at the judge's ruling. So let's get started. Now, some facts about this case. The applicant, as I had mentioned, is a professional hockey player. He was drafted by the Pittsburg Penguins Hockey Club, and he played for a number of minor league teams, one that happened to be the San Diego minor league team from 1977 to 1980. Now, keep those dates in mind. Now, the body parts injured were multiple, as you can see here, and you could read them for yourself. Now, the petition was filed by the defense, and it was filed in a timely manner, but they asked for reconsideration in 2022. So you see how many years later. Now, the applicant's attorney filed a timely, verified answer to the petition for reconsideration very shortly after. Now, again, you'll be surprised to see that the findings and award for this claim was in 2022, and it was petitioned for reconsideration was just less than 2 weeks after. And here the defense contends that by the order and the decision and the award, that the workers' compensation judge acted without or in excess of their powers. Then they indicated that the evidence did not justify the findings of the fact, and the findings of fact did not support the order's decision. So the medical reports and the applicant QME lack substantial medical evidence because he failed to discuss the effects of obesity in the applicant's orthopedic injuries. You'll find what they had to say about this. So some more facts about the case. The applicant's qualified medical evaluator, and they refer to this as an applicant QME and a defense QME. Let's be assured that it was just the QME that the applicant attorney scheduled the appointment with, and that's why they're called an applicant QME and vice versa with the defense. But this applicant QME issued his reports in several of them, one in 2019, 2020, and 21. So we're looking at 40 years after the actual claim that they say took place. But the QME did take a history of the applicant's work activity as a goaltender and a history of his injuries that he sustained. And he had several of them, including injuries to his groin from collisions on the ice, his hands, fingers from catching hockey pucks as a goaltender, his shoulders from falling on the ice, and his head and neck when he collided with other players. This gentleman also sustained jamming and jarring injuries involving his shoulders, elbows, wrists, hands, fingers, ankles on a repetitive basis while playing hockey. The applicant also continually sought medical treatment from the team's trainers, who provided temporary relief to permit him to continue playing games and participating in his practices. Now, the defense QME in orthopedics issued his report and noted that the applicant, the goaltender, sustained numerous injuries while playing professional hockey for multiple seasons, but he concluded that performing yard work and the applicant's obesity caused the orthopedic injuries. And he wrote, quote, "Yard work caused this man's pain and not playing hockey," close quote. The applicant's morbid obesity was also a significant contributing factor to the orthopedic complaints. Additional facts in the case are that the applicant's performance of his duties as a professional hockey player caused numerous injuries that resulted in the need for even left hip surgery. The applicant did testify in court that he lost his stability in his knees and sometimes had to use a cane to ambulate. He also injured his hands, and they say may require surgery. And he continues to experience problems with his memory due to numerous concussions along the way. So while working as a goaltender, the applicant experienced numerous bumps, bruises, and he would just get taped up, wrapped up, ice, given painkillers, and sent back on the ice to play. Now, after trial, the trial court issued their ruling and based their ruling on the following. They said that the applicant's QME's reports, 2 other primary care physicians, and a dentist report. Okay, so they had quite a bit of evidence here. The workers' compensation judge also considered the applicant's testimony and considered his credibility and demeanor as a witness. He indicated in his ruling the physicians listed above provided a detailed and persuasive analysis of permanent disability and explained the reasons for their opinions on permanent disability. Now that was very important. Persuasive is underlined here. Now the trial court found that the applicant sustained an industrial injury to those body parts as well. So they concluded that yes, indeed, this was a CT injury. In the appeals board discussion, however, they did make some very poignant examples and points here. They did indicate that the defendant was indeed correct, that the trial court relied on the reports of the applicant QME rather than the report by the defense QME. Also, a review of the record shows that the applicant QME considered the applicant's weight issues, and the applicant had gained weight over the years since his retirement from hockey. As an example, in one of the applicant's QME reports, he stated that the applicant, an ex-hockey player with left hip pain and erosive changes to the left hip. He also stated that the applicant was unable to walk more than a block. They provided a history that included obesity, hip pain, and knee pain. And at the time of the applicant's hip replacement surgery in 2008, the ex-goaltender weighed 300 pounds. The applicant QME reviewed the medical treatment records and recorded the applicant's weight gain that had occurred after he stopped working as a professional hockey player. So that wasn't the question, is when he gained the weight. It is what happened as a result. The applicant attorney also sought the services of an internal medicine QME. And this QME noted that the applicant's hockey-related job duties caused chronic pain to his right hip, back, right shoulder, and the need for daily over-the-counter medicine. His, quote, playing weight was approximately 210 pounds, where his weight at the time of the evaluation with the internal medicine QME was 334 pounds. So he's gained a third of extra weight that he had had. So according to this QME, the applicant's weight gain was causally connected to his decreased ability to exercise and walk more than 100 yards and his diet. It was reasonable and medically probable that the applicant's hypertension with the hypertensive heart disease resulted from significant weight gain, from decreased physical activity, hockey-related injuries, chronic pain, emotional stress, etc. And the internal medicine's reports were unrebutted, and the workers' compensation judge found them to be credible and well-reasoned. There you go. Now, numerous treatment records deal with the applicant's ongoing issue with weight since he retired from working as a professional hockey player. The ruling then cites many examples of the chart notes and reports that substantiate the QME's opinion, thereby qualifying the report as substantial medical evidence. Here we are again. In additional evidence, the applicant QME noted that the applicant did weigh 300 pounds at the time of the QME appointment. The operative report from Kaiser indicated that he had been a professional hockey player for many years and encountered many injuries, leading to arthritis of both of the hips per his history. So here they are, documentation is very important. Now finally, regarding the applicant's issues with his weight, they indicate, quote, 100% of the patient's current disability was a result of the continuous trauma suffered during the course of his career as a professional hockey player. So there you have it. All the evidence was provided and it was documented. So the Workers' Compensation Appeals Board took all this information and they concluded that there was no evidence in the trial record supporting legal apportionment of the applicant's disability to weight gain. Instead, they based on the applicant's testimony the nature of his employment duties, and other QME reports and the applicant's QME's reports that constituted substantial medical evidence. So it's well established that the relevant and considered opinion of one physician may constitute substantial medical evidence even if it's consistent with the other medical opinion. Remember, I used the term, as long as you are more persuasive than the other side, chances are you are going to prevail. So they denied the reconsideration by the petitioner, and they awarded the goalie his CT injury award. So I must tell you, I was surprised with this ruling, but let's discuss some takeaways here. So before we conclude this discussion, let's take a look at the labor code that played a real instrumental part in this ruling, and we're all familiar with it, but it's worth revisiting. Labor Code 3208.1, basically defining an injury. So we talk about the specific injury in A, but more importantly, we look at B, the cumulative trauma injury, occurring as a repetitive mentally or physically traumatic activities extending over a period of time, the combined effect which causes any disability or a need for medical treatment. Now here's what is important that we're going to discuss. The date of a cumulative injury shall be the date determined under Labor Code Section 5412. Labor Code Section 5412 states, quote, the date of injury in cases of occupational diseases or cumulative trauma injuries is the date upon which the employee first suffered the disability therefrom and either knew, and this is where it becomes important in this case, or in the exercise of reasonable diligence should have known that such disability was caused by his present or prior employment. So no, while the goaltender was working as a professional hockey player, he did not realize that he had sustained a CT injury, only until after the fact, way after the fact in this case, that did he put it together to determine that his prior employment, years and years prior, created his disability and his impairment. And this is what they set out to prove in this case. Wow, what an interesting and rather surprising outcome. Here we're reminded of two things here. First, the applicant attorney's QME basically qualified his medical opinion as substantial medical evidence, which is great, but he also provided the how and the why and facts and documentation to back them up. It appears that it was enough to influence the judge in this ruling. And it also proves that sometimes you don't have to just be right, but be more persuasive than the other guy. And number two, we learned that in the refresher course for the actual date of a CT injury, this case illustrates to us that there's virtually no statute of limitations when considering filing a CT injury in the state of California. Well, I'm Dr. Chris Rapoff and wanted to thank you again for taking the time to join me in this presentation. I hope you enjoyed it, and I look forward to sharing some other interesting cases again with you soon. Thank you.